All right, welcome everyone to our quarterly legal lowdown for Q1 2026. My name is David Feeks. I'm the owner and founder of the Parents Estate Planning Law Firm. Welcome. We're going to be answering tonight some frequently asked questions, not only that we get when we are talking to people at workshops and webinars, but just some questions that come into the office that we know get asked a lot. They get asked over and over, but we also want to answer your questions tonight as well over the course of the next half hour or so, or however long it takes to answer all of your questions. But we got a half an hour. So I want you to be able to pose any question that you've had about estate planning. You can post your question in the chat. So if you have a question, just go ahead and post your question in the chat. As I said, I'm going to get started with about 4 questions that I have that have come in recently and tend to come in often. So we'll kick things off with that set of questions, but feel free to add your questions to the chat. Just make sure your chat is set to everyone. And that way I'll be able to see, but everybody else will be able to see your question. And we'll get to everybody's questions. So the first thing that get asked over and over and has come up recently is, what should an estate plan include? And my philosophy on estate planning is that an estate plan should really include at least 3 components, and 4 if you're the parent of a minor child. So the first 3 are a plan for your assets. So every estate plan should include a plan for assets. What happens to your assets when you die? So that's number 1. Number 2 is a plan for incapacity. What happens if you're sick, unconscious, unable to make decisions for yourself, and you need someone to step in and make those decisions for you? So number 2 is a plan for incapacity. Number 3 is what we call a plan for legacy. And that is the part of the plan that captures what we refer to as intangibles, things that are important to you, who you are, what's important to you, values, stories, memories, guidance, advice, the things you want to share with your kids, with family members, again, that are most important to you, family stories, memories, things like that. And we build that into all of our planning for all of our clients in the office. But I think that's a really important part of estate planning as well. And then, so those are the first 3, and those apply to everyone, no matter you're a young family or an empty nester. The other thing that applies specifically to young families is a plan for your kids. So if you've got minor children, you need to have a plan for who steps in and takes care of your kids if something happens to you, or a guardianship plan for your kids. So those are the important elements of an estate plan, and that's what every estate plan, every good comprehensive estate plan should include. The next question that we get over and over and over again is, number 1, how to avoid probate, and can a trust help me to avoid probate? And the answer is, to the second question, can a trust help me to avoid probate? The answer is yes. Probate is something that everybody goes through who owns assets in their own name at the time of their death. So if you die and you own assets in your own name, those assets can't stay in your name, so they have to be, so the court has to get involved to figure out where they go next. And the court that gets involved is called the probate court. There's a probate court in every county. So for all of you that I saw coming through here that are in Middlesex County, the Middlesex Probate Court is in Woburn and in Lowell. And the court has to get involved to figure out what did you own and who is entitled legally to receive it next. So when I'm speaking with prospective clients, when I'm talking with clients in our office, and we're talking about probate, the question that usually kind of comes back to me is, I don't like the sound of probate, and I don't want my family to have to deal with a court process. Is there a way to avoid it? And alternately, is a trust a good way to avoid probate? And the answer is yes. A trust, there is a way to avoid probate. And yes, a trust is a good way to avoid probate, because a trust that holds your assets while you're still living keeps those assets, the assets that are in the trust, from having to go through that probate court process. So we won't get into the details of how that all happens, but just know that a trust is a way to keep assets out of a probate court process. And what that means fundamentally is a trust can make things as easy as possible for your family, as seamless as possible. It can give the people you want near immediate access to your assets in the event of your death or your incapacity. So your family isn't spending a long period of time dealing with court process, and a trust is private, which is one of the most important things about a trust. A trust doesn't get filed anywhere publicly. No one knows what's in the trust, doesn't know the assets in the trust, doesn't know who the beneficiaries of the trust are. So a trust keeps everything private. Whereas a public probate court process is always a public process where anybody and everybody can see what's going on. One of the other questions that we get, particularly about a trust, is can a trust help me to avoid estate taxes? And the answer is yes. A trust is a really good way to manage estate tax liability, because a trust can be set up in a way so as to either eliminate or at least to minimize your estate tax liability to the greatest extent possible. So a trust can be set up if you're married so that you can utilize the exemption amounts of both spouses instead of just one. And even if you're single, a trust can be set up to eliminate or even minimize, again, the estate tax liability. So a trust is the best way to help you to avoid or minimize estate taxes. And then the other question that I have on my list for tonight, before I get to yours, which is one, again, that comes up over and over and over again, is how often do I need to update my estate plan? And the answer is, and this is coming from me, and I've been working with thousands of clients over many, many years. And the answer that I've come up with is you should review your estate plan at least every 3 years. If you have an existing estate plan, you should be looking at it at least every 3 years. And the reason is because change happens. Change happens in your life, in your personal life, change happens in your financial life, change happens in the lives of your children or your beneficiaries. Changes happen in the law on a regular basis. And so it's important for you to review your plan on a regular basis to make sure your plan stays up to date with everything that's going on, either inside your life or outside of your life. What we do for our clients in our office is we reach out to all of our clients at least every 3 years for ongoing plan review meetings. In other words, we connect with our clients every 3 years, invite them in to schedule a plan review meeting where we get to sit down with our clients and kind of walk through the plan and walk through what's going on in their lives at that time and see if what's going on in their lives is precipitating any changes in the plan itself. And if so, then we can make changes to the plan as they're happening. And why that's important for all of our clients and for you as well is that way you know that when your family needs that plan the most, when they're pulling it down off a shelf, it is going to work the way you intended it to, and it won't become outdated or stale simply because time has gone by. So yes, an estate plan does need to be updated as often as necessary, whatever that means for you, but you should be looking at your estate plan and reviewing it with your attorney at least every 3 years at the most. Excuse me. So those are the questions that we had coming in tonight. What I want to go through now is go through the questions that you have. Okay, so the first question we have is someone who has already met one of the attorneys in our office, and what you should do next is whatever our team is reaching out to you and asking you to do, that's what you should do. But if you have any questions, reach out to Alicia and ask her, hey, Alicia, what do I need to do next? Or reach out to either Megan or Aaron, whichever of our paralegals is working directly with you, and ask them what you need to do next. Okay. So thank you, so for that question. Just reach out to our team and just ask them what you need to do next. One question is, could you please explain a Q dot provision in layman's terms, and also the difference between an individual trust and a joint trust? I'm going to take the second of those questions first, but I'll take them both. The difference between an individual trust and a joint trust. If you're single, you would create, and you're creating a trust, you would create a trust for yourself. You would create an individual trust. If it were me, I would create the David Feeks revocable trust, for example. If I'm married, I would create, because Paula is my wife, I might create the David and Paula Feeks revocable trust, and that would be a joint trust. So if you're married, you can create a trust together with your spouse and create it as a joint trust that you both create together, you both manage together, and you both are the beneficiaries of together. If you're single, you would only create your own trust that you create, you manage, and you are the beneficiary of. Now, if you are married, you and your spouse could still create your own individual trusts. So my wife, Paula, and I are married. I could still create my own trust. Paula could create her own trust. And we can have separate trusts, but we could also have a joint trust. So that's the only difference between individual and joint trusts. If you're single, you have to have an individual trust. If you're married, you could choose between having a joint trust together or each of you creating your own individual trusts. And there might be reasons to do one or the other. It's not an always situation. Sometimes it makes sense to create a joint trust. Sometimes it makes sense to create separate individual trusts. Now, going back to the Q dot, and I'm not going to go deep here, but a Q dot, which stands for Qualified Domestic Trust. It is a trust provision that's important if the person or one of a couple, if a couple is creating a joint trust and one of them or both of them are not US citizens, then a Q dot, a qualified domestic trust, is an important tax savings or tax deferral provisions in a trust. So that's what a Q dot is, and it basically allows the deferral of estate tax until the death of the surviving spouse, which normally is only available to a surviving spouse if the surviving spouse is a US citizen. But for a non-US citizen, we can create this special trust which will accomplish deferral until the death of the surviving spouse. And so again, at a 30,000-foot level, that's what a Q dot is, or a qualified domestic trust. It's a complicated piece of a trust, so a little bit more than we can get into in detail tonight, but great question. Next question, what are the advantages and disadvantages of naming a revocable trust which would have grandchildren as beneficiaries as the contingent beneficiary of an IRA or a Roth IRA? In other words, if you have an IRA or a Roth IRA, what happens? Can I name a revocable trust as the contingent beneficiary of my retirement account? And what are the benefits of doing that? The answer is you can, yes. The advantages of doing that are if your trust is set up to be an ongoing trust throughout the lives of your grandchildren, then naming your trust as the beneficiary is the way to make sure that those retirement account benefits remain in that trust. The disadvantages of doing that are it makes things more complicated with a retirement account custodian. It is simpler to simply name individuals as beneficiaries of a retirement account. But if your grandchildren are minors, that may not be desirable. And if you wanted to build in an extra level of protection, you would need to do that through naming a trust as a beneficiary. So the advantages are it protects the money if they're minors, and it can even protect the money if they're adults through an ongoing trust. But the disadvantages are it makes things a little more complicated with a retirement account custodian. Um, Next question is, my living trust is 1 year old. Do I need to file taxes in the name of my trust, or do I do it the usual name, in my name? A revocable trust does not need to file taxes on its own, Veronica. So a revocable trust doesn't have a separate tax identification number and is not a separate entity for tax filing purposes. So a revocable trust will almost always use the social security number of the creator of the trust. And as a result, if there is interest, dividends, income, or capital gains generated by the assets in the trust, you would report that income, those dividends, on your own personal tax return, just like you have done in the past. So you should be getting the same 1099s, you would file the same forms and the same schedules, and that's for a revocable living trust. So I'm limiting that to a revocable trust. That's what Veronica asked about. The next question, if we are married and create a joint trust, then how will the individual estate tax exemptions be utilized? Good question. I can only go so far here tonight without going deeply into legal weeds, and you don't want me to go into legal weeds. It's what you need to know is that a trust, a joint trust between a married couple, can be set up in a way so that both exemptions, the exemptions of each spouse, can be fully utilized to the greatest extent possible. For a married couple in Massachusetts, that means that you can use each of your $2 million exemptions, or a total of $4 million of estate tax exemption instead of just $2 million. By the way, the savings there is almost $100,000 in estate tax savings. That's the value of the extra $2 million exemption fully utilized, is almost $100,000 that gets to stay with your family instead of going to the Department of Revenue. And your family will know how to use that money much better than the Department of Revenue will. In other words, it'll benefit your family much more than giving it to the Department of Revenue. And that's about as deep as I can go into that. It's just important to know that you can through a trust. It's not critical to know how it happens. It's important for the estate planners to know mechanically how to set things up the right way. For you, it's just important to know that a trust allows you to utilize both exemption amounts. Rebecca, is there a minimum amount of wealth to create a trust? That's a great question, gets asked all the time, and the answer is no. There is no minimum amount of wealth necessary to create a trust. A trust is as appropriate for someone who has $200,000 worth of assets as it is for someone who has $2 million worth of assets, as it might be for somebody who has $20 million worth of assets. I have had clients who've created a trust when they had less than $100,000 worth of assets, because the benefit of the trust was important to them and was relevant to them. I have had clients with many millions of dollars who haven't created a trust and just did a will-based plan because to them, the trust, they didn't see the value, or it wasn't relevant or didn't resonate with them. There's no threshold. It's whether or not a trust accomplishes what you want to accomplish. And sometimes what you want and need to accomplish is irrelevant to the amount of assets that you have. For example, I have represented a lot of recently divorced clients who don't have that much in the way of assets, but knew more than anything, they wanted to keep their ex-spouse out of their financial lives. And the way they could do that was by creating a revocable trust to keep their ex-spouse out, especially when they had minor children. And so even in the absence of a significant amount of assets, the trust was valuable to them. It was important to them. It was relevant to them. And so they created it. So again, no minimum amount. The follow-up question there is, if it's not a revocable trust, what else could it be? There are two different ways to set up a trust. You can set up a revocable trust and you can set up an irrevocable trust. A revocable trust is something you create that you manage on your own and you are the beneficiary of, and you have full control over everything that goes into that trust. Real estate, bank accounts, investment accounts, whatever it is, if it's your revocable trust, you maintain complete control. An irrevocable trust is one that you create, but you have to put someone else in charge of it. You cannot revoke it, you cannot change it, and you cannot take the assets back from that trust. Once you put the assets in, they stay in the trust. And you don't have control over those assets anymore. So fundamentally, that's the difference between a revocable and an irrevocable trust. And at a high level, those are the two broad kinds of trusts you create. Within those two categories, there's all different variations and flavors and iterations of trust that you can create to accomplish different goals. But fundamentally, it's revocable trust or an irrevocable trust. Is there any downside to, I just lost that question, there it is. Is there any downside to creating a trust? Why doesn't everyone create a trust, or do they? This is an excellent question, and one I get asked virtually every time I'm talking with a prospective client. In my opinion, there's no downside to creating a revocable living trust. Admittedly, it costs a little bit more to create a trust than it does to just create a will-based plan. But the benefits of the trust so vastly outweigh just having a will-based plan in place. The cost differential just pales in comparison to the extra benefits. So in my opinion, there's no real downside. There's really no downside. Why don't most people create a trust? There's a lot of reasons, and I could do a whole hour-long webinar on the reasons why other lawyers don't suggest or offer a trust to prospective clients. In my experience, and this is just with the clients that we work with in our firm, 95% of the clients that we work with are creating trust-based plans, probably a little bit more than 95%. That is true year in and year out, year after year after year. It's never changed. And even of the 5% that start with a will-based plan, most of them, more than half of them, do so with the express intent of moving up to a trust-based plan in the near future. In other words, people say to me, I'm starting with a will-based plan, David, but within a year, 3 years, at our next review meeting, remind me that we need to move up to a trust-based plan, but this is the best starting point for me. So why doesn't everybody? I don't know. I have theories. Again, I could do a whole webinar on my theories. But in my experience, most of the people that we work with, the vast majority of the people that we work with, choose trust-based plans. And it's not because we're moving them into trust-based plans. It's because that's what they're choosing based upon what's important to them. Question, do you accept any legal insurance plans? MetLife, ERIG. The answer is no, we don't. I used to be on panel for ERIG. What I found is that the legal plans, the employer-sponsored legal plans, are not good full coverage plans. They tend to be very plain vanilla, middle of the road. There are some legal plans that will reimburse you if you hire somebody outside of the plan. So we have a lot of clients, mostly who have MetLife, who get reimbursement if they go outside of the plan, and we've helped them to get the reimbursement. But otherwise, we are not on panel for any legal plans because they are pretty bare bones. Okay. And then continuing, is there a mandate to pick U.S. citizens only as trustees for both guardians and kids and financial trustee? Financial trustee first. Yes, in a US-based trust, you need to have at least one US citizen or US-based company or financial institution serving as a trustee. And that's for tax purposes. So there has to be at least one US affiliated trustee, either a citizen or a US corporation or a US financial institution. Guardians, that requirement doesn't exist. And again, but there's a lot more that goes into thinking about guardianship and non-citizens as guardians, and more than we really have time to get into tonight. But for the fight, there's a very simple answer for financial trustee, and that the answer is yes, it has to be a U.S. citizen. Is there any downside to having the same person as children's guardian as well as a financial trustee? The answer is it depends. There is a potential, and I'm emphasizing the word potential, conflict of interest between a financial steward, the person who's responsible for managing financial resources for minor children, and the person who's physically taking care of the minor children. Those roles, there's an inherent conflict between those roles because the person who manages the money is solely responsible for the benefit of the kids, and the person who's taking care of the kids is incurring expenses that might get reimbursed from the financial person. So having someone in both roles potentially creates that conflict, but whether or not that person is right for you is up to you. I guide clients through this on a regular basis. Some clients choose the same person to be in both roles. Some clients choose different people to be in each role. It's up to the client. It's based upon who they have available to them and what the skill sets of the various people are. Sometimes the people you choose to raise your kids might not be the best financial managers, and so you might not want them. They might be great at raising your kids, but they might not be the very best people to manage all of the resources that would be available to take care of your kids. But that was a great question. Okay, we are right on the dot at a half an hour. Those were great questions, everyone. So thanks for asking them. Again, we do these legal lowdowns every quarter. So we'll be back again in a few months to do another one. Before you go, Paula's going to drop into the chat some resources for you beyond tonight. She'll drop a link into our resources page on our website, which has lots of guides and downloads and videos that answer a lot more questions. So we've created a whole video FAQ series. The other thing we'll drop into the chat that you can click on and download before you go are links to our empty nester guide. So if you're an empty nester, we will drop a link in here to the empty nester guide. And if you have young kids, we're dropping a link for our kids protection planning guide. So young kids protection planning guide is for you. Adult kids, empty nester guide is for you. No kids, pick one. There'll be lots of information about how to protect your assets, how to create an incapacity plan, and how to create a good legacy that you pass on to the people that mean the most to you. Okay. So again, appreciate all your questions tonight. Go ahead and download those links. Go ahead and hit our resources page on our website. And we will be back again in a few months to do another Legal Lowdown. Thanks everybody for joining us tonight. Really appreciate it. Take care.